So it looks like there are still people joining, but it's a little after 8:30, so we're going to get started with our mid-year employment law update. Good morning. Thank you for joining us. If you go to the next slide, we'll see what today's agenda is, which of course was laid out on the invitation that was distributed. But just as a reminder, Josh Wyatt's going to start us off by talking about what's going on at the NLRB. Should be very uplifting. Then we're going to turn to wage and hour law and provide you an update on some recent developments, recent cases in the wage and hour space. Then we'll talk about arbitration agreements and some Supreme Court developments in that area, as well as some legislative developments that you'll want to know about, especially if you have either used arbitration agreements or are thinking of using them, as most or at least many employers are. We'll take a very short break at that point, try to keep this thing moving, get people out on time before coming back and talking about return to work issues. I think a lot of companies are now in some sort of return to work mode with significant variations across the board. Talk about the legal implications of bringing people back into the office or into the workplace. And then we're going to close it out by talking about sort of a related issue, remote work arrangements. Obviously, folks have been working from home, those who can, for some time now. A lot of people want to continue to work from home. What does that mean under applicable federal, state, and local laws that have been driven by COVID and the implications of ADA accommodations and the like in connection with remote work arrangements. So I will go on mute here and turn it over to Josh to get us started. Thanks.
Thanks, Larry. Good morning, everybody. I hope that you've all skipped your coffee this morning, because what I'm about to tell you about the NLRB is going to really knock your socks off. When we do these in person, there are usually people standing by with smelling salts, but we'll have to make do for today. So just to get started, we're going to talk about some NLRB issues. And if your workplace does not have a union, don't worry. What I'm going to talk about impacts everyone, whether you have a union or not. We are going to be talking about, oh, sorry, just got to notice my voice was muffled. Is that better? Okay. So we're going to be talking about the General Counsel's agenda, the new General Counsel's agenda, a couple of case law updates, and then we're going to talk about the pending and ever developing developments at Starbucks and Amazon. So I'll start with the General Counsel's agenda. General Counsel Jennifer Abruzzo, oh, next slide, please. Jennifer Abruzzo has had a is very ambitious as General Counsel and seems to be following through on her ambitions. We're going to highlight 4 things that she's doing now. 4 things that she sort of put up front, and that's regulating or banning captive audience or other mandatory meetings, revising the NLRB's internal protocol so they can more quickly ensure faster investigations of unfair labor practices. She also wants to enhance and strengthen collaborative arrangements with other agencies. So if somebody makes a complaint to the NLRB, and they think, geez, I think the EEOC might have some interest in this, or geez, I think the DOJ might be interested in some of the anti-competitive aspects of this. They want to strengthen that collaboration. And she wants to really overhaul the damages available in labor law cases. So next slide, please. So captive audience meetings. Employers have had the right to convene a captive audience meeting with their employees, get them all together to discuss, what their labor rights are, and really to discuss anything for about 70 years. And Ms. Abruzzo intends to ask the NLRB to find such meetings unlawful. So that would mean that employers can no longer have a meeting with their employees and say, hey, isn't it great without a union here? And you have a right to not join a union. Most employers would tend to do that by highlighting how great it is and how great their benefits are without expressly saying we don't have a union here. But their meaning tends to be pretty clear. Connecticut recently passed a law amending the 3151Q, which now significantly limits an employer's ability to speak directly with its employees and makes it unlawful for employers to require employees to attend meetings to discuss political matters. And that term is defined to include the decision to join or support any labor organization. So under as a matter of state law, that's already problematic in Connecticut.
It's probably worth mentioning, Josh, that aspect of the statute, the Connecticut statute that precludes these sort of captive audience meetings to discuss labor organizations or unionization is almost certainly preempted by the National Labor Relations Act. So that'll be challenged, I'm sure, by some employer organization or another. If there's anybody out there that wants to entertain that possibility, please let us know. But I suspect that will end up being struck down. Of course, Abruzzo's initiative would be litigated through the National Labor Relations Board proceedings. And it's for those of you who have never dealt with unions, the captive audience speeches are sort of a staple of union election campaigns, where a union will try and obviously convince employees to join the union. The employer has the right to try and convince employees not to join the union, not only by talking about how wonderful the workplace is, but also about the downsides of unionization, such as union dues and other sort of restrictions and limitations that might come into play. So this is a major initiative on her part, because this is the captive audience meeting has been part and parcel of union election campaigning literally forever, going back to when unionization first became prevalent, 60, 70 years ago. So be interesting to see how that plays out. I will quiet down now and go back to you, Josh. I think you're up to the next slide, right?
Yes, we are now. Yeah. So collaborative enforcement. As I mentioned at the top, this is where the general counsel is looking to sort of do some information sharing with other agencies. So that can involve the IRS, the FTC, the DOJ's antitrust division, which has been relatively active lately, and the EEOC and the DOJ. So where you start with an unfair labor practice claim, that could, whether the unfair labor practice claim has any legs and has any merit, if there's a referral made over to the Department of Labor, that could result in a wage and hour audit or an EEOC charge. And it doesn't matter whether or not there's any strength in any of them. They can, as long as they have a basis to do it, they could still make the referral to the other agency and cause quite a headache from an enforcement perspective, and cause employers to need to deal with administrative charges on a number of fronts. So these collaborative enforcement arrangements, there are memorandums of understanding between the entities. That we have that now. They've been doing that for a long time, but Abruzzo wants to significantly strengthen those arrangements that they have. And she also emphasized the importance of combating retaliation in there. So she really wants to avoid, if you have a labor issue where somebody brings a ULP and then there's retaliatory action that maybe the IRS or the FTC or DOJ or EEOC could also have jurisdiction over. She wants to, she's made some private comments outside of the, public comments, but not officially through her memos, where she said that she wants to really put the screws to employers who are engaging in any kind of retaliatory activity. We do not have a separate slide for the faster investigation portion. I'll just point out that that's they aspire to improve their metrics and do things a certain percentage faster. I don't have any reason to believe they won't be able to do that. The NLRB tends to move pretty quickly, so I think if they want to move more quickly, they will probably find a way to do it. So next slide, please. All right, enhanced damages. So currently, the NLRB and its administrative law judges typically award back pay and reinstatement in the labor case. The GC wants the NLRB to be able to award much more expansive damages, and she wants them to exploit their make whole authority to award consequential damages. So that would mean emotional distress damages, loss of professional standing, reputational damages, in addition to those sort of economic back pay damages. This was briefed by the GC in a January 2022 brief in a case called Thrive, which is, I'm trying to remember, this is a sort of an internet age spelling, THRYV, spell Thrive. She characterized them, the available remedies, as feeble and put forth an argument for consequential damages. That case is still pending. The NLRB has been very solicitous of the public of asking for input into pending cases. So they invited that briefing. I believe that briefing has all been received, so we're waiting on a decision in that case. That's still pending. All right, next slide. All right, so this is a recent case involving employee speech. May have heard about it. It's a case involving Home Depot in Minneapolis. There was an employee in that case who was wearing clothing with Black Lives Matter slogans on it and pins. And Home Depot apparently stresses in their handbook and their policies that they want employees to adorn their orange aprons and their clothing with, a lot of sort of what's the term from Office Space? It'll come to me. Sort of like lots of pins and buttons advocating things, but they don't want political speech. So you can have something that says "Have a great day today," or something that's maybe a peace sign, but they want to avoid political speech. So this employee was not only wearing BLM attire, he was also advocating the discussion in the store and facilitating discussion with other employees. He put up notices on a corkboard in the back room. And he was asked to take it down because he was told it was political speech. And the district manager from Home Depot told him that if he allowed him to wear the BLM message to work, he would also have to allow employees to wear swastikas to work. To me, but the administrative law, this was asserted as the claim that was brought to the NLRB was that he was engaging in protected concerted activity, and that he was trying to share his message with other workers. And the administrative law judge said that the Black Lives Matter messaging lacked an objective and sufficiently direct relationship to the terms and conditions of their employment. And he said the message originated and is primarily used to address the unjustified killings of Black individuals by law enforcement and vigilantes. And he said to the extent the message is being used for reasons beyond that, it operates as a political umbrella for societal concerns and relates to the workplace only in the sense that workplaces are part of society. So there just wasn't a close enough relationship between the message and the workplace for it to be protected under the NLRA. And there is a similar case involving Whole Foods that's currently pending, and obviously Whole Foods is a non-union employer. So we'll see how those shake out. All right.
Procedurally, Josh, this was an ALJ decision, right?
Yeah. So this will go up to the board now.
Right. So presumably that will be appealed up to the National Labor Relations Board in Washington. The ALJ decisions generally don't really have much in the way of precedential value. So it's conceivable the case involving Whole Foods could come out differently depending what the board in Washington decides.
All right, next slide, please. So Starbucks and Amazon. So this is, I think, sort of dominated the labor news lately. Starbucks has had a lot of union wins. 250 stores have petitioned to unionize, 50 have already done that, but there are also notable, there's 9,000 Starbucks stores nationwide. But just this past Tuesday, Starbucks was hit with a petition in the Western District of New York, centered around the Buffalo store, where there was, I believe the Buffalo store was the first to unionize. And the petition alleged a slew of labor law violations against Starbucks, including that they were closing stores to avoid union activity, discriminating against union supporters, and refusing to bargain. The petition that was filed in the Western District was looking to reinstate 7 workers who they alleged were terminated for engaging in union activity. requiring bargaining at the store where the violations occurred. And the NLRB is also looking for a nationwide order halting Starbucks' anti-union efforts. The NLRB also tried this a few months ago in Arizona. That was rejected by an Arizona judge. Not sure what the Western District is going to do here. If it is successful and a cease and desist order is granted nationwide, Starbucks would have a pretty significant uphill battle because they'd face fines for any perceived violation of the order. Things could escalate to the level where individuals, if their conduct rises to the level of criminal contempt, could be jailed if they violate the cease and desist order. So whether or not it is granted, though, it certainly is an escalation on the NLRB's part to seek a nationwide cease and desist against Starbucks. As you probably also know, Amazon workers recently scored a major win by unionizing a facility in New York. And we've been trying to think about what's driving some of this. And it seems if you look at the demographics of the people who are the employees who are driving these campaigns and are bringing the union in, you're seeing an awful lot of social media users. Oddly, you're seeing an awful lot of college educated, baristas and Amazon workers, people who were impacted by a recession at some point and decided, I'm just going to go get a reliable job where I can pay back my student loans. But they have gone into these industries and they recognize what they perceive to be injustice in the workplace. And so they have brought in the union and made things very difficult for their employers. And their priorities are, sort of shifting back to, before the idea that like, oh, I have a college education, I'm out of school, and now I can afford to do anything I want. And, my employer is going to give me a real cushy job and I'm going to have a salary. They're looking and saying, I want more, more, more. I want better benefits. I want better pay. I want better hours. I want to be able to take bathroom breaks when I want. And so that's what they're presumably seeking there. Whether or not the allegations of what's happening at Starbucks and Amazon are actually true, not sure. But they're certainly using social media to try to have these campaigns happen in real time and to highlight what the employer is doing. I think notably for Amazon, Amazon and Starbucks, the social media posts and some TikTok videos are targeting the employer's counsel in those cases. So when the employer brings in a lawyer to sort of oppose the union drive, they're being shamed on TikTok and Twitter. So I'm sure that won't stop them from doing their job, but I think that's something we've certainly not seen before. And whether or not there are implications for other industries or employers, it's sort of unclear at this point. I think certainly Starbucks could be a bellwether for retail and other restaurant type employers. Amazon is sort of standing on its own, but obviously if Amazon were to unionize, that could have some significant implications for other large retailers. Because the employees of those retailers could look and see that the Amazon workers did it, and then they can do it too. So we'll be keeping an eye on that and seeing how that pans out. And I think I've hit my time. You're muted, Larry.
Thank you, Josh. Appreciate that. I should have mentioned at the beginning, and we can go ahead to the next slide just to transition to the next subject matter. But if you have any questions, please put them in the chat. We'll try to get to as many of them as possible, either during the course of individual presentations, or I think Jordan might have mentioned at the back end. We hopefully we'll have some time. I think we're so far on a pretty good pace here. Thank you, Josh. And we'll do the best we can to address your questions. But if you pop them into the chat, we will cover as many as we can. Make a significant shift here and move from the NLRB to wage and hour compliance. I think I'm going to start this off, right, Josh? Okay, so we can go to the first slide. All right, so FLSA cases, wage and hour cases, don't get to the Supreme Court all that often. You probably see one every second or third term. It's something of a head scratcher for those of us who do this kind of work. The Supreme Court agreed to hear a case that came out of Texas called Helix Energy Solutions Group versus Hewitt, and I'll explain in a minute why that's kind of a a surprise that they took on this particular case. It deals with the highly compensated employee exemption, which you may recall was something new that was added by the Department of Labor when the white collar exemptions were kind of overhauled most recently, which I think goes back to 2004, if I remember correctly. They've established this new streamlined test for exempt status as an administrative executive or professional employee for folks owning at the time over $100,000 a year. That's gone up a little bit. And so for those individuals who had that kind of compensation rate, there was a streamlined duties test. So I think, as most of you probably know, in order to be exempt under one of the white collar exemptions, generally there were 3 requirements. You have to be paid on a salary basis. That salary must be of a certain amount, exceed a certain amount, and your duties have to fit within the executive, administrative, or professional exemption, or outside sales exemption, as the case may be, in order to qualify for the exemption. This case involved an oil rig supervisor. So there was no question in this case that his total compensation exceeded the threshold for a highly compensated employee. There was also no issue that his duties qualified for an exemption as well. But the question was whether he was paid on a salary basis under the operative test. So for the highly compensated employee exemption, that threshold was at least $684 a week. And this gentleman far exceeded that. He was actually paid $963 a day. So we're talking about someone who's up closer to the $200,000 range than the $100,000 range. So a very highly paid employee. The problem was that he was paid on a day rate. And this case went up to the Fifth Circuit on a salary basis question. After the Fifth Circuit panel ruled, it went up to an en banc panel, which means the entire Fifth Circuit, all the judges on the Fifth Circuit Court of Appeals. There were split decisions, as you might suspect, in that context, but ultimately the majority concluded that this arrangement, this day rate arrangement, did not satisfy the salary basis test, not because day rate arrangements are improper per se, but what the regulations require is 2 things: that there be a weekly guaranteed minimum amount that's paid each week, and a reasonable relationship between that weekly guaranteed amount and actual compensation, so that avoids situations where there's sort of an artificially low weekly guarantee and the balance of the compensation significantly higher is tied to the quality or quantity of work, which would be inconsistent with the salary basis test. Here, for whatever reason, the company did not provide a weekly guarantee. They argued that the daily rate and the regular schedule that this gentleman worked, in effect, created a weekly guarantee. But the Fifth Circuit rejected that argument because conceivably, if the employee worked 3 days in a particular week for whatever reason, he would get $963 times 3. And if he worked 5 days in a week, he'd get $963 times 5. So there was no specific guaranteed amount. And the decision sort of notes with a degree of curiosity, explaining that they could have simply just guaranteed him $4,000 a week, and they would have been fine. But for whatever reason, they didn't do that. So this is sort of a unusual arrangement. Most employers don't pay day rates. It's a unique kind of a job in a very unique kind of an industry, the oil industry. So it raises the question of why the Supreme Court would even take this case. The ruling, if it's confined to the issues that were discussed and litigated before the Fifth Circuit, is going to have very, very limited application. It will have no application to, I suspect, anybody on this webinar. And it will have no application to probably 99% plus of employers. So, we've been trying to figure out why they might take this. There's some thought that the court may have questions about whether a salary element of the white collar exemption test is even appropriate given the statutory language, but nobody briefed that or argued that to the Fifth Circuit. That would be a major development. But there's no indication that's the direction they're going. So it's a little unusual. There is something of a circuit split Other circuits have suggested that the weekly guarantee requirement doesn't apply to highly compensated employees or under the highly compensated exemption. So that may be the reason, but that seems, kind of odd. So anyway, interesting case, unusual case, and we'll see what the Supreme Court does. Maybe there's some major development here that will take place, and we're just not seeing it based on what happened below. So we can go to the next slide. So another exemption that a lot of people don't know about, it could have some fairly broad application for employers that may have employees who don't neatly fit into the typically administrative exemption or not outside salespersons, and they can't, and therefore can't take advantage of the outside sales exemption. This exemption is referred to as either the 207I exemption or the inside sales exemption. And basically what it does, it applies only to in the retail or service arena, and it establishes an exemption, or really an exception, to the overtime pay requirement for employees whose regular rate of pay is greater than 1.5 times the applicable minimum wage. So you're talking about a relatively insubstantial amount. The federal minimum wage is still 7.25. Believe it or not, there are, of course, higher minimum wages in various states and localities. But in terms of this particular federal exemption, the pay rate only has to be 1.5 times the applicable minimum wage. But the kicker is that the compensation that the employee receives for a representative period, not less than a month, at least half of that has to be in the form of commissions on goods or services. So this is really the folks who are doing inside sales work. But we've seen this applied actually to window washers in a case out of the Seventh Circuit a number of years ago. So if you can structure the pay in a retail or service setting, then you might have an opportunity to take advantage of this particular overtime exception. One issue that comes up in a lot of these cases is what is a retail or service establishment? That's kind of a broad term. There used to be a wholesale exemption in the FLSA for retail or service employees. So even whether they did inside sales or not, that was dispensed with back in the 60s. But courts still tend to look at the regulations that were in effect back then in defining a retail or service establishment. It's a kind of a flexible test. The regulations talk about 75% of the annual dollar volume of the sales of goods or services are not for resale. That is essentially retail. But also the employer has to be in an industry that's recognized as retail, whatever that might mean. And obviously that's a concept that might change over the years. The case we sort of made reference to in this slide out of the Western District of New York, I think Josh put together these slides. He must have some affinity for Buffalo. He's now had a couple of cases that he's talked about from up in that area. But this involved a real estate company, and the court concluded that the real estate industry lacks a retail concept, or at least it wasn't so clear that there was a retail concept from the record before the court, that it would resolve the case on a summary judgment motion. But that lacking retail concept would preclude the application of this particular inside sales exemption. But keep this in mind if you're in an environment that is a service type environment or what might be traditionally considered to be retail. This might be a way to structure employee compensation to get out from underneath overtime obligations. If you have folks who do some sort of sales, and again, on the inside, the outside sales exemption is different. You can structure their compensation on some commission type arrangement that exceeds half of the total comp. You might be able to avoid overtime obligations. So something to keep in mind. Going to the next slide, but sticking with the same case, not only in the wage and hour arena, but I guess in discrimination context, all sorts of litigation matters that we deal with. We invariably get the question of, can I be held individually liable? And of course, the answer to that question varies depending on what statute we're dealing with. But certainly for wage violations, both under federal and most states' laws, individual executives can theoretically be held liable for wage and hour violations. And this particular case raised that issue. And the court focused on several factors under what's called an economic reality test, the key being the degree of control that the individual has over the workplace. In this case, it was the CEO of a corporation that was a little bit diversified, and the claim was against one of the business units. And so the factors the court looked at, as you can see on the slide, is whether this individual, the CEO in this case, had the power to hire and fire the employees in question, supervise and control their work schedules or conditions of employment, had a role in determining the rate and method of pay, and was responsible for maintaining employment records. In this case, the court happened to find that there was a factual dispute on the issue. The CEO had submitted an affidavit in response to the motion in the case that said he did not have operational control over these particular inside sales employees. He didn't make hiring decisions with respect to those employees. He didn't set company policies or work schedules for these individuals, for the inside sales employees. And he lacked authority to unilaterally determine pay rates, or didn't improve the commissions and bonuses for these employees. And as you might suspect, as the CEO wasn't responsible for maintaining employment records. Just again, something to keep in mind. Those of you in HR, when these claims come in, I'm sure executives are asked whether they can be held individually liable. And this is basically the test that most courts employ to make that determination. It's a little bit different under state law, but generally speaking, if the executive has a significantly active hand in running the business on a day-to-day basis as it relates to the employees who are suing, they can theoretically be held individually liable. Next slide. So moving outside really the FLSA context, or at least a sort of a nuanced area of the FLSA, sort of step one point is wage claims can't be waived. So if an employee is owed wages, they can't agree to take less than what they're owed in exchange for signing release. In a severance agreement, you can't compel an employee, or an employee can't agree to waive a wage claim. So if you get an employee to sign a severance agreement with a release and they're owed money, whether it's overtime wages or just unpaid wages tied to commissions or something else, they can still sue for that. Wages are considered sacrosanct. So those kind of claims can't be waived. And then there's the issue that we come across frequently with startup type entities. A lot of times newly formed businesses or businesses that are in sort of their infancy will make arrangements with folks. Sometimes they call them independent contractors. They may be misclassified as such, but also with employees. They're strapped for cash. They're in the process of seeking funding, and they will offer equity or some other form of non-cash compensation during the early stages of employment. So they have a workforce to get their business up and running, and they don't have the obligation to pay wages that they can't afford to pay. That's a no-no, at least with employees. So obviously, if there are legitimate independent contractors, the wage laws, the FLSA and other wage payment laws don't apply. But even if the employee agrees to it, and even if it's in a contract, it is still unlawful under the Fair Labor Standards Act and under our applicable state laws. It's essentially a minimum wage violation, and the Acosta case is an example of that. That case also raised a prompt payment issue. There is nothing in the FLSA about how the frequency of paying wages. Almost every state has a law that requires that wages be paid within a certain time period after the paid period ends, usually running from 8 to about 15 days. But the FLSA says nothing about it. The courts have implied a prompt payment requirement without any specifics. Courts in this area, in the New York area, the Second Circuit, which covers New York, Connecticut, and Vermont, have read into that requirement that generally speaking, wages must be paid within 2 weeks, or else you have an FLSA violation of the implied prompt payment requirement. So that was an issue in this case. Both of those were issues. As you can see from the brief description of the facts, the plaintiffs were not paid at all for a couple of months. So that's a violation of the minimum wage requirement. And it's simultaneously, of course, a violation of the prompt payment requirement. The employer tried to argue that the employees were qualified for the administrative exemption. But of course, when they're not being paid at all, they can't possibly satisfy the requirement that they receive a salary of at least $684 a week, which is the minimum in New York City. Next slide. So this is sort of kind of a flip side, although the facts make this one something of an outlier. A recent case also out of the Southern District of New York, when the employee in question had a specified salary and employment agreement of $80,000 a year, wasn't paid for the first few months at all, but brought a case essentially that sounded in breach of contract. Tried to argue in response to a dismissal motion that this is an FLSA violation, because essentially a minimum wage violation, but because I wasn't paid at all. And the court said, well, you pled it as a breach of contract claim. You're not seeking FLSA damages. What you're seeking is the salary that was promised you in the contract, and you can't call a lemon an orange, essentially. So this was a little bit of a different set of facts, where the minimum wage issue really wasn't properly pled by the employee. That doesn't mean the employee didn't have a good breach of contract claim. He just couldn't seek the enhanced damages under the FLSA liquidated damages and the like. So let's go to the next slide and shift gears pretty dramatically just to talk about interns and volunteers. I suspect many of you have students working, excuse me, in your offices for the summer. These days, a lot of companies will just pay. They call them interns, but they will just pay them. But if you don't pay them, then you have to look at whether that's legal. First of all, with regard to volunteers, there's no such thing in the private sector. So you can have an arrangement with a student or anyone else to work for free. That option only applies in the public sector, and for civic, charitable, or humanitarian type employment, where free services are being offered. So you can put aside the notion that anybody can volunteer to work for you, but interns is a different matter. And a recent example out of the 11th Circuit down in Atlanta, which covers the southeastern states, involved in an individual who was working in an autopsy forensic photography training program. Sounds like an exciting opportunity there. And it was treated as an unpaid intern. And the question, of course, was whether the individual was entitled to be paid. And the 11th Circuit looked at the same basic 7-part test that courts up here in the 2nd Circuit look at. And you'd want to analyze that same test too if you have unpaid interns this summer and are asked to determine whether they need to be paid. The first element of that test is that the intern and the employer must clearly understand there's no expectation of compensation. That was meant in this particular case, is there was a clear understanding that this particular plaintiff would not be paid. The second element of the test is the extent to which the internship provides training that would be similar to that which would be given in an educational environment. In this case, this particular county program was apparently highly regarded and provided valuable practical experience, and hence satisfied that requirement. The third requirement is that the internship is tied to the intern's formal education program by integrated coursework or the receipt of academic credit. This particular intern was in school eligible for academic credit, but the court noted that there was considerable experience comparable to what a student would get in a 4-year degree program. The fourth requirement wasn't applicable in this particular case. It requires that the internship accommodate the intern's academic commitments by corresponding to the academic calendar. Of course, with summer folks, that would be easily satisfied since most students are off for the summer. The fifth requirement is that the duration of the internship be limited and provide beneficial learning. The court here said that 6-month internship was not, quote, grossly excessive. Typically, a summer internship program would meet that requirement. It's usually 2 or 3 months. The sixth requirement is that the work complements rather than displaces the work of paid employees. In this particular case, that was a disputed question as to the extent of displacement. But for your purposes, you don't want interns subbing in for employees that were just laid off or about to be laid off, or taking work away from employees who are being paid and reducing their workload or their hours, as the case may be. They shouldn't be displacing employees. They should be working side by side and essentially learning from them. And the last requirement is that there's an understanding that there's no entitlement to a paid job at the conclusion of the internship. So you may end up hiring folks who go through your intern program, but as long as there's no commitment made to do so, no obligation undertaken, then that requirement would be satisfied as it was here. So there's like one more wage and hour related topic that Josh is going to cover if we go to the next slide about pay transparency laws that you may have read about. So I will turn it back to him.
I'll cover it in 1 minute to not overlap too much more. So we're going to talk quickly about pay transparency laws, which you may be aware of from Connecticut passed one that went into effect in October of 2021, requiring disclosure of a wage range for positions. So that requires the wage range is supposed to be the range that you anticipate relying on when setting the wages for a position. So has to be disclosed in vacant positions and for existing employees at hire if they change position or if the employee requests, they make a request for the wage range for their position has to be provided under the law. Massachusetts has proposed legislation that will require employers with 50 or more employees to provide current employees and job candidates with pay scale information for the positions that they hold or for which they're interviewing. Two that are still pending and are coming pretty soon and have some potentially long-reaching implications, New York City and New York State. So New York City's law, which mimics in some ways Colorado's law, will require businesses with at least one employee in New York, even in a remote capacity, to include salary ranges in job advertising. So if you have a company in Connecticut and you have one employee who works remotely out of Brooklyn, then you need to put the wage range. I mean, I shouldn't say Connecticut, New Jersey, because Connecticut already has that law. So if you're a New Jersey business and you have one employee in New York working remotely, you have to include the salary range in job advertising. And the New York Commission on Human Rights said that covered employers should follow the new law when advertising for positions that can or will be performed in whole or in part in New York City, whether from an office, in the field, or remotely from the employee's home. New York State, the legislature's passed a similar law to New York City, requiring disclosure of salary ranges for a promotion or transfer opportunity that can or will be performed in the state of New York. That has gone up to the governor's desk. She has had there's been some lobbying efforts by the business community claiming that some small businesses will be negatively impacted by the law because they don't have, big human resources apparatus to put out a wage range. I'm not sure that's going to be a persuasive argument because you need to have a wage range in mind for a job you're going to post. So we'll see how that goes. But that's actually on her desk, so that could be signed any day, and 270 days later that will be in effect. So that said, I'll pass it back to Larry.
Thanks, Josh. Just a note for those of you with operations in multiple states. This is sort of a trend now with a lot of states adopting this kind of pay transparency law. You can see some of the states listed in the last bullet point that have already enacted legislation, and others are considering it. So let's go to the next slide, which will be the lead into our discussion of arbitration. We can skip the cover page. Nicole Dwyer is going to cover the first few slides on this topic, so I will turn it over to her.
Thanks, Larry. Can we advance to the next slide? So I'm going to be covering some state law developments, but first I want to provide a little bit of context about the backdrop against which those state laws have been enacted. So we'll start with the Federal Arbitration Act, which, as you may know, sets a federal policy that protects arbitration agreements pretty significantly. It prohibits arbitration agreements from being treated differently than other types of contracts. And the Supreme Court has repeatedly interpreted the FAA to mean that an arbitration agreement can only be invalidated on grounds that other contracts could also be invalidated on. So basically, special rules that treat arbitration agreements less favorably than other contracts are going to be prohibited under the FAA. And that extends to state laws that conflict with this protection of arbitration agreements. So in general, you can't have a state law that's going to treat a arbitration agreement less favorably than any other kind of contract. The Me Too movement brought significant criticism of forced arbitration of sexual harassment claims. And it was against that backdrop that several states tried to enact legislation over the last few years to prevent forced arbitration of certain employment-related claims. So that's where we get into these state law developments, one of which was in New Jersey. There was a 2019 amendment to New Jersey's law against discrimination And it prohibited the prospective waiver of any substantive or procedural right that related to a claim of discrimination, harassment, or retaliation. The New Jersey law was interesting in that it didn't expressly address anything about arbitration agreements, but it was worded broadly enough that there were questions about whether the law would prohibit pre-employment arbitration agreements that as applied to certain employment-related claims. So based on those arguments, there was some significant litigation that questioned whether it was preempted by the FAA, and several New Jersey courts held that it was. Next slide. So that's been pretty well established in terms of the New Jersey case law. It's being treated as preempted by the FAA. New York also enacted a similar piece of legislation, except that this one actually went as far as to expressly bar arbitration of sexual harassment claims, except where inconsistent with federal law. And courts have interpreted the prohibition itself to be inconsistent with federal law because it conflicts with the FAA's arbitration protection. But the interesting thing is that this was all before some recent federal legislation that I'm going to turn it over to Larry to talk about and how that might impact some changes going forward.
Okay, thanks, Nikki. It's kind of interesting. Nikki and I actually had a case in New Jersey shortly after that law was, or that amendment was enacted. We made the arguments that Nikki alluded to. One, that the amendment doesn't actually say anything about arbitration, so it doesn't preclude employers from requiring pre-dispute arbitration of LAD claims and New Jersey law against discrimination claims. And second, that if it did, it would be preempted by the Federal Arbitration Act. And we briefed that issue pretty extensively before a state court judge, but the plaintiff's lawyer kind of chickened out and ended up agreeing to arbitrate before the judge ever ruled. So unfortunately, we did not get the decision of first impression on that issue, but it turned out, at least on the FAA preemption question, we were right. I don't think the New Jersey courts, Nikki will tell me if I'm wrong, addressed the scope of the amendment at all. So we haven't seen that. Of course, it's kind of irrelevant. So let's go to the next slide. Josh, I don't know if you want to jump in. There was a question jumping back to pay transparency. I don't know if you could see it in the chat or.
I was just responding in the chat.
It says, does the Connecticut pay transparency law cover remote employees also as well as Maryland, is how it's worded.
Well, I can tell you real quick, the Connecticut Department of Labor interprets the act to say, yes, it does cover remote workers. That's non-binding. That's their opinion is going to be persuasive to a Connecticut judge, but from their perspective, yes, it does cover applicants and employees who reside outside of Connecticut and who are applying for remote work and who may never even step into the state of Connecticut, as long as they work for a Connecticut employer.
Great, thank you. So there is a new federal law, sort of tracks what Nikki was talking about in New York. It's focused exclusively on claims involving sexual assault and sexual harassment. It had to be that narrow. I think there is some support in the Biden administration for getting rid of pre-dispute arbitration altogether, but they recognize that'll never get through the Senate. So they scaled back their ambitions and passed a law that precluded pre-dispute arbitration agreements as it relates to claims, or really the statute uses the word cases, alleging sexual assault and or sexual harassment. So just to be clear, if an employee brings a claim for sexual assault and sexual harassment, whether it's the EEOC, state agency, in court, and the company works out with the employee through counsel or what have you, that they agree to arbitrate the dispute, that's fine. A post-dispute arbitration agreement would be fully enforceable. What this law prohibits is agreements made in advance. So when an employee joins the company, for example, they sign an arbitration agreement as a matter of company policy. That arbitration agreement applies to all employment-related claims, as they typically do. If the employee has a claim for sexual assault or sexual harassment now under this new law, which went into effect in the early March, they can't be compelled to arbitrate that claim. So if you filed a motion to compel arbitration of such a claim, you would lose and you'd keep that in court. The big issue with this statute, or one of the big issues, is really that, as I mentioned, it talks about cases. I don't know why it used the term sexual harassment or sexual assault cases as opposed to specific claims, but it does sort of raise the question if there is a complaint alleging multiple claims, say race discrimination or some other form of gender discrimination, as well as sexual harassment, is arbitration of the entire case barred, or can you essentially divide it up and have a court compel arbitration of the non-sexual harassment claims while the sexual harassment claim is litigated in court? We're just going to have to see how that plays out. Of course, you may not want to be litigating in two forms for a variety of reasons, including the cost of doing so. But you may end up having that scenario play out because, as I'm sure many of you know, oftentimes a sexual harassment claim or a case includes other types of claims within the four corners of the complaint. So that'll be a issue litigated because of the lack of clarity in the legislation. Next slide. So you want to take a look at your arbitration agreement. Certainly, if you haven't adopted arbitration agreements and plan to use them going forward, in drafting those arbitration agreements, you want to be cognizant of this particular new legislation. There's sort of an open question and debate about whether it's important or essential to specifically carve out sexual assault or sexual harassment claims, or perhaps you can simply get by with you agree to arbitrate all employment-related claims except to the extent prescribed by law, which may work as well. You've got to be a little careful because some states will invalidate an entire agreement if there's one unenforceable clause. So you want to look at what state you're in, or at least the employee is in, that you're asking you to sign an arbitration agreement before you decide how to carve out or not carve out claims covered by this law. It's a good idea to include a severability clause because that might obviate the problem. If a court finds the provision unenforceable or in violation of the Enforced Arbitration Act, they could just sever that unlawful provision and move forward with the rest of the agreement. And you'll want to reserve the right to do that. So take a look at your arbitration agreements, be aware of what the statute requires, and contemplate that as you go through the drafting and review process if you use arbitration agreements or are thinking of doing so. Next slide. Just to note that the statute says nothing about jury trial waivers. There's questions as to whether a standalone jury trial waiver is enforceable, which is really a state law issue. But that might be a way to at least avoid a jury trial on sexual harassment cases, even if you can't get it into arbitration. Next slide. So a couple of Supreme Court decisions that have come down. The Supreme Court seems to love arbitration cases. There's a slew of cases under the Federal Arbitration Act, both in the employment setting and elsewhere. This particular case involved a Taco Bell franchise. They required their employees to sign arbitration agreements. This particular plaintiff, Robin Morgan, did so, but she had some wage and hour concerns and brought not only an individual claim, also a class claim. The arbitration agreement included a waiver of the right to bring class action. She did so anyway, but notwithstanding the existence of the arbitration agreement, Sundance decided to litigate a little bit in court. They moved to dismiss. That failed. They went to mediation. That failed. So we're 8 months into the litigation. Discovery is about to get underway or has just started. And they say, well, let's try and get this thing into arbitration. The plaintiff, Morgan, of course, argued that Sundance had waived the right to arbitrate the case by virtue of participating to that extent in the litigation. The court applied what has become kind of a traditional test of waiver in this contest, asking whether Sundance knew of its right to arbitrate, acted inconsistently with that right. Two tests that are easily satisfied here, but also prejudice was the third element. And especially since discovery hadn't really commenced yet, whatever was done in court could be simply transitioned over to the arbitration forum. There was no real prejudice that Morgan could point to. Hence, the case was compelled to arbitration. That was upheld by the Eighth Circuit and went up to the Supreme Court. And there, and I think it was an 8-1 decision, or it might have been unanimous. I may be getting two decisions confused, but there was not much in the way of dissent here. The Supreme Court reversed in sort of a twist on their typical approach to arbitration. The court noted that the equal footing requirement, that arbitration agreements be treated on equal footing as any other contract, cuts both ways. And the waiver test outside the arbitration context did not include a prejudice requirement. So the courts had fashioned what is essentially an arbitration specific rule that put arbitration agreements on better footing than any other contract when it came to waiver. So the court determined that the prejudice requirement was inapplicable. That essentially puts Sundance back in court, because clearly the other two requirements of knowledge of the arbitration agreement, knowledge of its existence, and acting inconsistently with the right to arbitrate seemingly can be satisfied. I'll go back down for that purpose. Next slide. I think in our promotional materials, we advertised that there was another Supreme Court decision on the way that had yet to be decided, and this is that case. It's called Viking River Cruises versus Moriana. This is a California-specific case. It deals with the Private Attorney General's Act under California law, which is a very interesting provision that allows employees to seek civil penalties for labor code violations acting on behalf of the state. So because that the PAGA law not only provides for a 75% penalty, that 75% of the penalty that's awarded goes to the state, and 25% goes to the aggrieved employees, but there's also a fee shifting provision. So you can get attorney's fees. So this is a very attractive claim. And virtually every wage and hour case filed in California includes a PAGA count to try and beef up the settlement value of the case and enhance the potential attorney's fee award. So the question in this case is whether a plaintiff can be compelled to arbitrate a PAGA claim. The California Supreme Court had ruled a few years ago, or answered that question in the negative a few years ago, saying the PAGA claim is brought on behalf of the state. The state's not a party to the arbitration agreement, and therefore arbitration cannot be compelled. The Supreme Court took a different view. If you go to the next slide, and basically concluded that employees can be compelled to arbitrate individual PAGA claims if they sign a pre-dispute arbitration agreement that would cover such claims, as pretty much any well-constructed arbitration agreement would do. Although claims on behalf of other aggrieved employees who are not parties to the arbitration agreement can't be compelled to arbitration, that's kind of a moot point, because without an individual claim, there'd be no standing to pursue claims on behalf of other aggrieved employees. So as a practical matter, the end result was that the PAGA claim would end up in arbitration on an individualized basis, which of course is the result that the employer was looking for. So this is a very employer-friendly decision. You might want to look for a legislative fix in California. Justice Sotomayor's decision or opinion reference potential legislative fixes that might get around this problem and might pass muster before the court. We'll have to see how that plays out. But for the time being, at least with those of you with operations in California, maybe you've already been hit with one of these PAGA cases, or you inevitably will be if you have any employees, because everybody gets sued for wage and hour violations in California. This is sort of a welcome result if you also have arbitration agreements with collective action or class action waivers. So that's the end of the arbitration discussion. We're going to take a short break. We're at 9:30 now. I think we're close to on time. So let's make it about 5 minutes, and then we'll come back at around 9:35 or so. In the meantime, if you want to type any questions into the chat, we can try and answer them before we get started with the next segment. Thank you. Okay, why don't we get started again? If you can go to the next slide. And I think this is you, right, Mary?
This is me.
All right, so this should be exciting.
Yeah. Well, it's certainly, I have to say, a little more exciting than wage and hour and NLRB and arbitration.
That's it.
which is exciting for me because I get to talk about it after the dry runs. So good morning, everybody. My name is Mary Gambardella. I think I know a lot of you, but for those of you who don't know me, I'm also a partner in the Labor, Employment, and Litigation Department. And I'm going to talk to you about the return to work considerations and kind of means modifying post-pandemic. So everybody knows now we're in a situation where we like to think it's over or there's light at the end of the tunnel. And some of you have always had people who were at work because they were essential workers. Some of you are trying to bring people back to work or by now have already brought them back to work. And some of you are actually considering hybrid situations going forward, either temporarily or indefinitely. So we're going to talk about some of the obstacles, some of the considerations, some of the hurdles that all of you should think about. Next slide, please. So we always profess the need for trying to issue pronouncements, for lack of a better word, that talk about the message. What's the message? You always want to manage people's expectations. So one of the things you want to tell employees is that you're continuing to follow guidelines of the CDC. Let's not forget OSHA. So while OSHA's mandate was rejected by a court as overstepping its authority, OSHA still has the power to determine whether or not you have a safe workplace. So you want to create a message that people have to follow and can follow. And one of them is, what are my policies? What are my practices about keeping the workplace safe? Do I want to require masking? Do I want to keep my vaccine mandate? We'll talk about that in a minute. What are the policies that I already have in place that may have to be modified to ensure that reopening, whether hybrid or total, will meet federal, state, and local guidelines? So these are the things that you have to sort of think about as you jump into it. What are the training needs? We always talk about training in our group, and there is not a lot of time and ability to train everybody about everything, but you may want to think about this. What is the training that we might need for managers, for rank and file, when they come in to talk about these guidelines? Do we need to refresh training about analyzing requests to continue remote? And I'll touch on that, but the next segment is more about remote work arrangements. But I think that talking about refreshing training is going to be very beneficial to you and worth your time. What are the procedures now we're going to have in this pandemic phase about reporting, contact tracing, and so forth? So when we were in the height of the pandemic, or when numbers, and that was a long time, right? It wasn't that long ago, we would have a process, most of us in place, for people to report in when they were diagnosed or exposed, and how we would notify others, and so forth. Are we going to continue to do that now? So those are the things you have to think about. And so you also want to talk to people about what I'll call vaccine and mask shaming. And we'll touch on that in a minute. And, try to involve your employees in making suggestions about what would make them feel confident to return to the office. Now, there are going to be some who are just going to say, I don't want to come back. I'm nervous. And we'll talk about them momentarily. Next slide, please. So some of you may have a vaccine mandate that you had that you're keeping. Some of you may be deciding whether or not you need to keep the vaccine mandate. Some of you had mask mandates. Now that Indoor mask mandates are falling away. You're deciding whether or not to keep them in certain scenarios. For example, whether or not social distancing is possible with their workstations, at meetings, and so forth. It's really important these days to remind people that if we make it a choice, they should not be treating their colleagues one way or another disparately because the colleagues opt to wear a mask, to not wear a mask. I've been getting a lot of questions about masking, where some people choose to wear a mask in the office, and that's an option you should provide, and except for some other industries which are discrete and unique. Colleagues should not presume they have COVID and they're in the office with COVID, or they've been exposed to COVID and they're in the office. And interrogation of each other is to be discouraged. So when there's personal choice about social distancing, then wearing masks, employees have to be told this is a choice. They shouldn't they shouldn't jump to conclusions about what it means and doesn't mean. I know it's easier said than done. But we have to have civility in the workplace. We've always talked about that, right? But now there's a new reason for people to kind of pick at each other. And these are going to become reasons, like some of the other reasons you've had all along, to discipline people and to counsel people and to take proactive ways to promote team play and civility in the workplace. Next slide, please. Okay, so the Equal Employment Opportunity Commission and the NLRB had announced a joint effort to increase protections for whistleblowers against unhealthy and unsafe workplaces. So in that announcement, the Equal Employment Opportunity Commission, that is the EEOC, gave some examples. And one example was where an Asian American employee reported a coworker's comments about Asian people spreading COVID-19. Now that falls into harassment based on ethnicity. And that's something that we're seeing happening and that employers have to be aware of and react to, just as they would react to any other forms of discrimination. An employee who requests remote work as a disability accommodation even after you open. We're going to talk about that. So even in the case where you are trying to bring everybody back, or certain people can no longer work remotely for whatever reason, and the individual claims a medical condition that they would say requires them to continue remote work, and we'll talk about that analysis, but let it be said that the analysis has to be the same as any other analysis you were doing under the Americans with Disabilities Act when people request an accommodation. Or an employee who requests modified protective gear that can be worn with religious garb as a religious accommodation. So again, we're going to talk about religious-based accommodations because they seem to be popping up still. So keep in mind that filing a charge, a complaint, external lawsuit, regardless of whether the underlying allegation of discrimination or harassment ends up being substantiated, is a protected activity. So remember, the old rules still apply. We have new situations, new scenarios, but the old rules still apply, including people who were exempt from being vaccinated, either under your mandates or just in general, from being harassed because they're not vaccinated. And that's if people know about it, obviously. But those are the kinds of things we see that are continuing. So you have to also understand that making the request is protected activity. So retaliation against an employee for requesting an accommodation which can include continued remote work, can likewise be considered protective activity. Next slide, please. All right. If you continue to have vaccine mandates, if you had them and want to continue them indefinitely or permanently, or you want to have vaccine mandates apply anew, which I don't think that's really the most frequent situation we see now, then you have to remember the old rules still apply. There are two exceptions to mandating vaccines. One is a disability-related exemption, and two is a religious-based exemption. Now, these exemptions continue to plague employers in terms of what's enough. So the quote down below, to drop or not to drop, that is the question. I'm talking about your vaccine mandates, if you have them. Do I drop them now? There's no obligation to keep them unless you're in an industry where that is required, or federal workers. There is no obligation to keep them. And so this is a question that a lot of employers are facing now. Do I drop it? If you don't drop it, then you still have to recognize these two exemptions. If you do drop it, then you have to decide how you're going to approach employees who are there under the prior vaccine mandate, and know that new employees or other employees don't have to be vaccinated. The question that just popped up is, can I require new hires, hold on, I got to bring it back up, to be vaccinated but not require current employees? If you want to do a vaccine mandate going forward, unless there's some type of employee relations backlash, which you'd have to deal with, not as a legal issue, but again, as an employee relations issue, you could require people coming in now, again, subject to those two exemptions. So what I would suggest is that on any application form, you make sure you post that, and you would make it clear, and we have language if you need it, that subject to exemptions recognized under state, federal, or local law, you have to be vaccinated. Then you have to decide, does vaccination mean 2 shots, booster? You know, what does it mean to you? And managing expectations is important. And then if a new hire presents an exemption, you have to analyze the exemption just as you would for a current employee. So let's go to the next slide. All right. So let's talk about religious-based accommodations. So we had, during the period where many employers were implementing a vaccine mandate because the EEOC said you could, guidance was issued addressing the parameters for religious exemptions. And so here's what an employee had to do to get an accommodation, an exception from the vaccine mandate based on a religion. The employee had to notify the employer that there was a conflict between the vaccination requirement and the employee's sincerely held religious beliefs. And we told our clients, identify a point of contact in the organization to review these requests, because you want some systemic approach to adjudicating these requests. And you didn't want to leave it in the hands of management, who tend to have too much deviation and don't understand all the legal implications of analyzing these requests. And so what we also told employers is a letter was enough, okay? A letter was enough. But if the employer had an objective basis for questioning whether the religious nature or the sincerity of the particular belief was in doubt, they were entitled to make a limited factual inquiry and seek additional information. I'm going to give you an example of an objective basis, because there aren't a lot. If an employee says, I have a religious objection to vaccines, but in the past, they got flu vaccines, and you know they got flu vaccines. Is that an objective basis to say, well, wait a minute, now we want to ask more questions? We would be inclined to say, yes, that's an example of an objective basis to question the religious belief. So objections that are based on political, personal preferences are not religious beliefs, and that has never been the case. And then you have to engage in the interactive process. So when you get a request for religious accommodation, you have to engage in the interactive process just as you would before in terms of terms or conditions of employment. So that means case by case basis. It is discouraged and difficult to get a set of objective criteria that you're going to apply when you assess these things. You can do things like it has to be accompanied by a letter from the employee identifying the religious belief. Those kinds of things can be set forth. But otherwise, the analysis has to be case by case. And when can you deny it? Well, like any other accommodation analysis, when there's an undue hardship, but what does that mean? I'll tell you what it doesn't mean. It usually doesn't mean money. It usually doesn't mean money, okay? It doesn't mean that just because they could spread to others, that's an undue hardship. What that would mean, what that would require is, how can I protect the others, right? Is this person a direct threat? Those are the key words, and that's hard to prove, as you can imagine. So the one thing I will tell you is that documenting your analysis of each case is extremely important. So document, document, document. So we'll talk about undue hardships because that also applies with requests for accommodation because of a medical condition. Now, why are we still talking about religious accommodation if we're beyond the vaccine issue? Because if someone's unvaccinated because of a religious exemption and you want to continue to have them work remotely, or in order to let them come into the office because you want to bring them back to the office, you have to analyze whether or not they can be brought back safely with respect to others. It's still a consideration you have to think about. Next slide, please. A new case we just read that was just issued is really helpful to this analysis. You know, there's a lot of legal decisions about what's undue hardship. Again, that's a fact-specific analysis. But we just had a case in the Third Circuit, but it's definitely persuasive and influential, even though not in our circuit. A USPS, a postal employee, told the post office that his religion required him not to perform work on Sundays. Now, this is not necessarily related to the post-pandemic issue, but it helps us with the reasonable accommodation analysis going forward. And he told them he couldn't work on Sundays, but he was scheduled to work on Sundays because the post office had a mandate to deliver certain things on Sundays. The post office tried but could not find employees to switch shifts with him. And so he asked for a transfer, but there were no positions that did not require Sunday work. He was disciplined for absences because he just wouldn't show up. And then he eventually resigned and he sued for religious discrimination under Title VII. Now, I will tell you, if you read the details of the case, the post office did a bunch of other things besides trying to get somebody to cover his shifts, beside telling him he could come after services on Sunday, beside trying to help him look for other positions that didn't require Sunday work, but all to no avail. But what's really critical is to note that I think what helped this defendant get this case dismissed on summary judgment was all the things they went through to try and accommodate this individual. The court concluded the employer did not provide a reasonable accommodation because swapping with somebody else didn't eliminate the conflict with the religious beliefs. However, exempting him from working on Sundays would have caused more than a de minimis cost because it actually imposed on his co-workers. So it wasn't dollars, it was the imposition on others who would have to cover for him. Disrupted the workplace and workflow and diminished employee morale. So the court held that they had done more than what was necessary to establish that this accommodation would cause an undue hardship. Next slide, please. Now let's talk about the medical accommodation. So again, this analysis is the same as it's always been. And it's going to come up again if, for example, somebody, when you're trying to bring people back physically to the office, whether totally or in a position that is held by this particular employee, they say, we need to keep working from home. Why? Because we have a medical issue. So when you get that request for an accommodation, you go through the steps you always went through. You can require medical documentation, and you should require medical documentation. There are way too many times where we leave it to managers to talk to the employee, and we're getting all the information from the employee. It doesn't matter what the employee tells you, you've got to get medical documentation. That the medical documentation needs to verify that the employee has a qualifying medical condition and that and what are the requested accommodations. We have a case right now with one of the partners on this webinar where the employee said the doctor was going to request an accommodation. The manager asked what was the scope of the accommodation. The employee made a representation, but when they got the note, it said something totally different. So again, make sure you get backup documentation. Then you have to engage in the interactive process, like always. What is the accommodation? Is it reasonable? Is it reasonable to let somebody continue to work remotely? That's a case-by-case basis. And so I get clients saying to me, well, the others are going to think, well, why can't I work remotely? It's the same answer as always, ladies and gentlemen. You can't reveal anything about anybody's particular situation. What's reasonable? What's suitable? What are the essential elements of the job? Can they continue to be done remotely? Now, the one thing we did read before is the EEOC took the position that just because you allowed remote work during the pandemic, they would not hold it against you. Like before, you established precedent, right? That you can do something, it's not an undue hardship. However, going forward, that remains to be seen whether or not they can live by that representation. And the only way you can deny an accommodation is if it's unreasonable. And again, what are the things you have to consider before denying it? Are there protective measures you can put in place? If, for example, the person says, I have an underlying medical condition, COVID is still a threat to me, can you modify a work schedule? Can you move their work location? Can you allow remote work? Can you keep them on leave, or can you reassign them? So you've got to go through the steps in order to create a defensible position. The direct threat standard, which is another way to deny accommodation, is a really high standard. And I will tell you, it's beyond just saying, well, they can give somebody COVID. Next slide. So again, here it is. The continuation of remote work is what we're seeing most often right now as a requested accommodation. And the EEOC guidance, which is what we have right now, says that you have to do it case by case. I can't repeat that enough. Can they perform the essential functions of their job remotely? And it's not, no, because I don't want them to. It's, can it be done? You don't, if you decide, for example, to temporarily remove an essential function of the job and give somebody time, that's okay, but it doesn't mean you have to do it indefinitely. Very important. Document, 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 and issue written parameters of the remote work arrangement. Next slide. So here's the slide again of the reasonable accommodations that you should think about before you deny an accommodation request. The leave of absence. Also remember FMLA and Connecticut paid FMLA. The employee doesn't have to say a magic word for you to say, look, we can't accommodate this, but what we can do is give you additional time off for a period. And don't forget your benefit eligibility. You can apply for FMLA or Connecticut FMLA for job protection. Flexible work schedules, reassignment, et cetera, et cetera. So, and the request itself constitutes protected activity, whether you deny it or not, for purposes of retaliation claims. Next slide. Let's just take a quick hypothetical. XYZ Corporation has decided to relax its masking protocols, making wearing a mask recommended instead of mandatory. John, employee, is uncomfortable being in a workplace where some people are not wearing masks. He submits a medical note saying he was previously diagnosed with anxiety, and the change to the masking policy is exacerbating his symptoms. John, employee, wants to work from home, and participate in the mandatory team meetings via Zoom, even though other members of the team will be attending in person. Can the company require John to return to the office? The answer, as it is always, is it depends. What does his doctor say are the restrictions? Does the physician say his restrictions can be accommodated with, for example, letting him wear a mask, letting him not be in a crowded room during a staff meeting, putting him in a different workstation? Anxiety, that's an interesting concept. So as we all know, mental health conditions can qualify as disabilities under the ADA and state law. But is the anxiety disabling, or is he just nervous? Simply being nervous about being in the office is not a qualifying disability. So it depends. Next slide. Just quickly, since September of 2021, just so you have a feel for what's going on out there, at least 66 cases were filed against private employers for refusing to grant exemptions or for insufficient accommodations. And then in only 3 of those cases where the employers put the workers on unpaid leave as the accommodation for not getting vaccinated, did the court issue an injunction, but then on a temporary basis, but then they were lifted. 59% of the claims involved religious objections. 33% contested the employer's handling of religious and disability accommodation requests. Less than 10% of the cases were based on ADA medical accommodation request. And then of the EEOC charges, 90% were brought under Title VII, which is discrimination, retaliation, and harassment. 10% under the Americans with Disabilities Act. 25% of these lawsuits raising religious objections were dismissed. And we don't have outcomes yet. Next slide, please.
Mary, there was a question as to whether
Sure.
those 66 cases are all in Connecticut. I'm pretty sure the answer is no, but
No, it's the ones we can find right now nationwide.
thank you.
Thank you, Larry. And so here's a little pretty graph and a link to a Bloomberg Law report about a case. Next slide. So what's the moral of our story? What are the return to office takeaways? Communication, managing expectations, confirming the commitment to a safe workplace and what you're doing about it and what the employees need to do to maintain safe workplace environments. Determine what positions have to return to the office, how many days a week. Have a remote work policy with some parameters, but remember you have to be flexible on a case-by-case basis. Make sure you're following the safety protocols necessary for return to work and that you enforce them just as you would any other failure to follow policy by workers. Explain as much as possible in an objective manner the process to return to work and the safety protocols in place. Develop an accommodation policy to address concerns. That means telling them the process, the contact person. It doesn't mean establish objective bullets for when you're going to deny an accommodation. And figure out how to handle employee pushback and employee relations matters with a clear plan about how and who will help the organization through those situations. Those aren't easy situations, and we're seeing a lot of those today. So I want to thank you all for listening, and I'm going to turn it over to my partner now for your last segment.
Thanks, Mary. Could we advance to the next slide, please? So Mary spoke about remote work arrangements as a potential accommodation. What I want to focus on for our last segment is the compliance issues that arise out of remote work arrangements. These are questions that you should be asking yourself regardless of the reason for the remote work arrangement. This is really focused on what does it mean to have employees working for your company from other states? So for those of you who have folks at home who are working in Fairfield and Hartford and Shelton, wherever else, that's not the question we want to be talking about right now. We're really thinking about you're a Connecticut-based employer and you have somebody who moved away and is working remotely from Florida, or you hired someone new from New Jersey and they're working from their home there. One of the questions Mary asked, the answer was, it depends. This is going to be a huge area where it depends. It depends on your business. It depends on the state where your employee is. So the point of this segment is just to flag the questions that you should be asking yourself, thinking about working with counsel for follow-up on, speaking with your accountant for the tax-related questions, and possibly with your benefits folks in terms of state leave programs. Next slide, please. So initially, as we know, necessitated by the COVID-19 pandemic, remote and hybrid work is absolutely the new normal. I've seen lots of statistics about employee preference here, and it should not surprise anyone that there is a huge preference for people wanting to continue to work remotely or at least hybrid. So one report from last year was 90% of employees who thought they were as productive working remotely, and almost all of those people wanted to continue to work remotely post-pandemic in order to be happier. Next slide, please. So with the increasing prevalence now of long-term remote work arrangements, we're definitely past the time where this was a Band-Aid to get us through those first few weeks or months in 2020. We are now looking at long-term and permanent remote arrangements. People are working farther and farther away from their home offices. I don't know if you had the experience of people who moved during the pandemic, and you're learning now that they have scattered to the wind. But even for those workforces that function efficiently in a remote environment, you really need to think carefully about what remote arrangements may mean for you from a compliance perspective. These arrangements can have significant implications on compliance with federal, state, and local employment laws. Next slide, please. So the first area we wanted to touch on here is anti-discrimination laws. You may know that different states have their own anti-discrimination laws that may extend protections that are available to employees under federal law. It gets even more granular than that. There are plenty of large cities that have their own anti-discrimination laws. That includes New York City. When an employee lives and works remotely in a location separate from where their employer does business, you may start to see questions about which state and local anti-discrimination laws apply. Is it the laws that cover the employer from where the employer's brick and mortar location is, or are they the laws that are in effect from where the employee is sitting from their desk, wherever they may be? So for example, if an employee works remotely for a New York City employer, has never set foot in the New York office, can that employee bring claims under New York State and New York City's employee-friendly anti-discrimination laws? New York City's anti-discrimination laws go beyond, New York goes beyond federal law, and New York City even goes beyond New York State law to be incredibly protective with regard to various protected categories. So we saw one recent decision so far, Schreiber versus Centerview Partners LLC. If we could go to the next slide. So according to the court there, an employee whose entire tenure consisted of remote work from New Jersey for a New York City employer did not have rights under New York anti-discrimination laws. But this is an emerging area, so we don't really know yet whether other courts will take a similar approach. Even if they do, the Schreiber decision leaves open a lot of questions. What about employees who worked in the office pre-pandemic, or those who it's a temporary arrangement and they'd be expected to return post-pandemic? Or, for example, employees who come into the office periodically or have to be available to come into the office periodically. We think the most conservative approach here is to assume that the most stringent law applies, meaning assume the law applies that grants the most protection to your employees and work backwards from there. Next slide, please. So another huge compliance area with remote employees is paid leave programs. Connecticut is joined the ranks of states that have paid family and medical leave programs within the state. Connecticut's, like many others, is funded through payroll deductions. So this applies, we know, to employers who are located outside of Connecticut with employees working from inside. What we don't know is the reverse. A Connecticut employer with remote employees working elsewhere, and we haven't seen clear guidance from the Connecticut Paid Leave Authority. What you may want to do, though, is look at the employees who you are taking payroll deductions for in connection with Connecticut Paid Family and Medical Leave Act. You may be surprised to find that when you began that, you either missed people who should be covered, or perhaps that you are taking the deduction from employees that may face eligibility questions because they're out of state were they actually to apply for Connecticut paid family leave. In addition to those paid leave benefit programs, many municipalities have sick leave laws. So just as an example, Pennsylvania does not require that employers provide paid sick leave, but both the cities of Philadelphia and Pittsburgh do. So that's just an example of how granular some of these requirements can be. It's not just which state your remote employees may be in, but it may be as specific as which city. Employers with remote workers must be aware of and comply with paid leave laws for the locations where their employees work and have an understanding of whether or not their employees are covered, even if the employer is not. Next slide, please. Another area is drug testing. So I think this is most likely to come up for remote employees with pre-hire testing. Seems unlikely, but not impossible. You would be conducting, for example, reasonable suspicion testing of a fully remote employee. But employers should be evaluating their pre-hire drug screening process for remote employees. State law varies widely on what is permissible and what is required for the drug testing processes for employees. For example, in Maine, drug and alcohol testing cannot be conducted at all without a written drug and alcohol policy that has actually been approved by the state's Department of Labor. We're also seeing a lot of activity from state legislatures with regard to cannabis, and states are beginning to implement legislation that treats cannabis differently than other drugs, either by restricting an employer's ability to test for cannabis or by adding additional procedural requirements before an employer includes cannabis in a drug panel. Next slide, please. Wage and hour laws is probably the biggest category where we see variation state by state and city by city. So, for example, California requires payment of vested and unused vacation time as wages. Under California law, wage is considered a part of an employee's compensation, and it is owed to them as soon as it is accrued. So use it or lose it policies are not permissible in California. So if you're a Connecticut employer that has a use it or lose it policy, but you've got a remote California employee, you've got to look at that from a compliance perspective and see if you need a caveat to your policy that says something like subject to applicable state law, but you do have to make sure to monitor that in terms of how you're applying it. Other states like Wisconsin employ different tests for whether or not an employee is exempt. So it varies from the Fair Labor Standards Act, whereas in Connecticut, we largely see Connecticut wage and hour law track the FLSA. That's not the case across the country. And then finally, each state has unique tax and withholding requirements. We're not tax professionals, but this is definitely an area where you should be speaking with your tax folks about this, because having employees in other states, one, it could create a nexus to that state where you need to be thinking about tax implications for your business for having remote employees. But two, you want to be working with your tax professional and possibly payroll to make sure that you have all the settings and set correctly for an employee in a remote state if you need to make adjustments for their withholdings for that state. Employers must be aware of and comply with these jurisdictional differences when they have employees working remotely from out of state. Next slide, please. Okay, non-competes. Again, states vary widely in their approaches to non-compete agreements, and numerous states have implemented legislation in this area over the last few years. You should consider these variations before you are shipping off offer letters with your standard cookie cutter non-compete agreements. For example, narrowly drawn non-competes remain permissible under Massachusetts law, but there are a whole series of statutory requirements. They include a 10-day notice period to the employee before they be required to sign the agreement and start the position. Particular requirements that the agreement provide for garden leave during the restricted period where the employee can't work for competitive companies. These requirements apply to a non-compete offered to anybody who has been a resident of Massachusetts or working in Massachusetts for at least 30 days immediately preceding the separation of employment, no matter what the agreement says about choice of law. So you can say, forget it. I don't want to deal with this headache of the Massachusetts non-compete requirements. We're going to put in here that Connecticut law applies. Won't matter for the purposes of trying to enforce that agreement against a Massachusetts resident. So when considering which state's law will apply, courts are going to consider factors such as the current locations of the employee and the employer, the places or place where the agreement was negotiated and executed, and whether there's a conflict between the state laws where one state has a materially strong public policy regarding non-competes. Next slide, please. So overall, our goal here is just helping you identify and mitigate the potential risk here. So the first step may just be a census. You may not know where people have scattered to since the pandemic began. We suggest requiring employees to obtain authorization to continue working out of state and to survey your existing workforce to determine who's moved without notification. You might consider limiting approved remote work locations to create a smaller universe for compliance. So rather than have to think about 40 states where you have remote workers, maybe you want to limit it to approved work arrangements from a certain area. Next slide, please. Take an affirmative approach to compliance. You should consider, as I mentioned at the beginning, working with counsel to compile an overview of state and local laws where you have remote employees or where you're considering authorizing a remote work arrangement. As you consider remote work requests, make sure to consider those on an equitable basis to avoid discrimination claims. Obviously, not all jobs lend themselves to remote work, but within a job category, you should be assessing those requests on an equitable basis. Work closely with tax professionals, payroll, and your insurance broker to confirm that taxes and state disability insurance programs are set up appropriately, and to make sure that you are enrolled in the correct state unemployment insurance programs. I didn't touch on it before, but unemployment is also an area where we're seeing this issue come up. That was so often the case and remains the case with misclassification issues. It's coming up now for remote work. So employee working remotely from Indiana loses their job, files for unemployment in Indiana, their employer is Connecticut based. And now there's this question about where are they eligible for uninsurance benefits, for unemployment benefits. And then finally, confirm that you have an appropriate system in place to make required employment law postings accessible for remote employees. If you use an intranet or a portal, those are oftentimes acceptable ways to make those postings available. But you have to give it some thought because the break room posters are not going to cut it for your employee that never steps foot on premises. think that's the last slide in this segment, and we have left some time here for questions.
Thanks, Caroline. I don't see any questions in the chat. If you have questions, you can certainly send them to us, any one of us. I think our email addresses are somewhere posted. You can always go to the website, wiggin.com, and find contact information for all of us. So please feel free to take advantage of that. Also, I believe we'll be sending out a survey afterwards just to get some feedback on the presentation. That would include an opportunity for you to give us some thoughts on subjects that we should cover or you'd be interested in hearing about at our next program. We typically do another program like this in the fall, October, mid to late October. That's sort of the tentative plan. The idea may be to do that in person if possible, but we're still sort of exploring our options in that regard. So hopefully we'll see many or all of you at our next program when we get that scheduled, whether that's live or via this less personal Zoom approach. With that, I think I still don't see any questions, so we can close it out. Thanks, everybody. Appreciate it. Have a good day.
Thanks all. Have a good one.
Thank you.